5 seconds. Start. The allegation against the fourth respondent made is that a manipulation has been made in the revenue records and the insertion of the word servery has been made fraudulently in a different ink which is recorded in the remarks column in the said records. Sri Misra has then invited the attention of the court to the antecedent records to contend that this manipulation could not be made in all the revenue records either in the parental family caste status of the fourth respondent or in the family where she has been married. The revenue records have been filed along with the writ petition to substantiate the aforesaid submission. It is urged that on the strength of a manipulation in the record of rights of 1331 fastly that the caste certificate has been obtained by the respondent number 4 on the strength whereof she contested the election as a backward class candidate. According the respondent number 4 having taken recourse to such a fraudulent practice which is established on record, an appropriate writ should be issued for declaring her elections to be a nullity. Shri Mishra has relied on 10 judgments, including several of the Supreme Court, to urge that a petition would be maintainable for declaring such election as a nullity on the grounds so raised. He has further invited the attention of the court to 3 judgments to urge that fraud vitiates all solemn proceedings, and in this context the constitutional bar under Article 243K would not apply so as to relegate the petitioner to file an election petition. Responding to the aforesaid submissions, Learned Counsel for the State Election Commission has cited the decision of Lakhpati versus State of UP passed in WP number 5121/2016, containing that the nature of dispute raised herein is also a matter that would raise questions of evidence and which cannot be gone into under Article 226 of the Constitution of India. Learned Counsel for the respondent number 4 has also urged that the inquiry with regard to the alleged manipulation in the revenue records cannot be made the basis for raising a challenge in as much as the elections have been contested on the basis of a caste certificate and in respect thereof a complaint was made before the issuing authority, namely the Tehsildar, who has submitted a report on 13/3/2016 before the district magistrate urging that the said report be considered as the complainants with regard to the caste certificate are not true. The aforesaid recommendation has been made under the government orders that have been enforced for conducting an inquiry into the status of a caste certificate where the district level screening committee is chaired by the district magistrate. He submits that so long as the caste certificate stands, the election of the respondent number 4 cannot be annulled as she has contested the elections not only on the basis of entries in the revenue records but on the strength of a caste certificate that was issued by the competent authority after making full inquiry.